sorry. There's a district court case involving the woman who encouraged her housekeeper or told her, if you leave, you can't come back, which was an accurate statement of the law, and she was prosecuted in that case?
Justice Sotomayor, you're referring to the Henderson case out of the
Yes.
District of Massachusetts, which is the case that the amicus briefs focus almost entirely on. And I think even if you were troubled by that case, that would be one district court prosecution.
Well,
I don't think fought
what I find interesting is that the government there also hypothesized that a lawyer who told his client that if he what the consequences were of leaving, that you would prosecute the lawyer too, and the lawyer there is earning money for that statement. He's giving advice.
I'm not sure whether that's what the government said there. It's certainly not what we're saying now.
Well, I know you are. But could you tell me exactly how you want us to rewrite the statute? I think if you're going to call it aiding and abetting or soliciting, that you have to write in a specific intent, don't you?
I just dispute the premise. I don't think we're asking you to rewrite it. I think we're saying these are words that connote aiding and abetting. They're terms of art. They bring the old soil with them.
With it, and that's an intent requirement.
Correct.
And here, the defendant asked for an intent statute to come in.
Not quite. The intent requirement that's required for aiding and abetting, and the one that we accept here is the one the court referred to in Rosemond. That's the intent of facilitating making the offense succeed. What the defendant asked for here—
Well, with aiding and abetting, you have to intend to make it succeed, and I'm wondering what you're making succeed, meaning nothing— you haven't proven that these aliens were going to leave anyway.
I actually think we have here. There was testimony that there are two non-citizens at issue. Both of them said their visas were expiring. They would have left, but Mr. Hansen said, you can stay because I'm going to make you a citizen.
Right. But so we have to write in an intent. We have to take the words and define the words encourage or inducing to mean aiding and abetting or soliciting. What do we do with our Ilonis point, where we said if we're going to define a statute, we shouldn't define it to put in words that Congress took out. And Congress, previous to this statute, had the words aiding and abetting and soliciting and took them out. So now we're putting back in what Congress took out?
I disagree, Justice Sotomayor. I think this is an area of the law where commentators and the court has long recognized there are lots of different words that have overlapping meanings that legislatures and courts use to capture these concepts of solicitation and aiding and abetting. The Lefebvre Treatise cites about a dozen of each species. Induce and encourage are among them both. And I don't think that the fact that Congress took out assist and solicit in 1952 suggests that it intended to change the meaning of this words. It was, in fact, adopting the shorthand that this court had just 5 years earlier in the Hoy case given to the predecessor statute. When the other words were in there, this court shorthanded it as encouraging or inducing.